We'll start this one more time, and I apologize for the technical difficulties here. This is Brandon Roché, and I'm here at the CILA World Headquarters in downtown Houston, Texas. We're going to cover today what I deemed, what are the attorneys talking about? An intro to UC immigration law and working in a law office. And real quick, I think most of you probably know this, but CILA is a project of the American Bar Association, or the ABA. So throughout this presentation, I'll be referring to ABA model rules. And the ABA is a nationwide voluntary bar association, different from your state bar associations that all attorneys have to be a member of in some capacity to practice. And the ABA ethics rules that I'll cite here carry persuasive force, although they're not mandatory in every state. Almost every state models their own ethics rules on these rules, and I have the Texas rules cited where they're necessary. So just so you know what I'm talking about when I talk about ABA and model rules. You can leave any of your questions in the chat box as we go through today, and we'll also have time at the end to go ahead and answer some questions too. So you should all be muted in the actual room, but please feel free to put your questions or anything you want to say into the chat box, and we're monitoring that as we go through today. So without further ado, I'll go into what we're going to cover today. You guys know how this works. I'm going to tell you the different sections that we'll go through. Then we're going to go through them. Some of this will be review. Some of this may sound familiar, and I hope to put the pieces together in a way that makes sense. The idea is to give you some background on procedures and terminology that you probably hear all the time, jargon that you hear used in the law offices that you work in, but maybe haven't had a chance to see where does this come from or why is this done that way. So this is a little like college political science or government class and first year of law school all rolled into 1 hour of a webinar. I'll be honest, I struggled to take some of the complex material and boil it down to an easily digestible PowerPoint slide. So if it seems like I'm dumbing things down, it's because I'm trying to cover a lot of ground, not because I think someone has to be a lawyer to understand these concepts. Okay, so we're going to start with the broad immigration overview. And I have here your three basic types of immigrants under the law, and each leads to a different path or none at all. So your non-immigrant visas at the bottom there are things like tourist visas, student visas, where they're expected to return to their country. There's even specific visas for foreign fashion models. There's athlete visas, performers, things like that. And those are those people that come in on a certain type of visa like that. You've got at the top your undocumented immigrants, right? And that railroad doesn't lead anywhere because they're not on the path to getting their LPR or U.S. citizenship status. And there in the middle is kind of the idea, right? The railroad track that people want to be on and that we want to get most of our clients on in some way or another. So you start by getting them onto an immigrant visa path, and from there they can become an LPR and onto U.S. citizenship. So what are those legal immigration paths that people can get themselves on? Well, there's a couple different kind of bubbles of types here, and employment visas are big ones. These are e-visas, the kind that come from a company sponsoring a person who comes to the U.S. to do a specific job for a specific company, right? There's also family-based immigration that we're all familiar with. This is where you have a relative who is an LPR or U.S. citizen, and they're going to petition for someone back home or someone that's already here in some capacity to join them, right? And that's a major way to immigrate. There's also the diversity lottery, and it's just that. It's kind of a random selection from applications from countries that the State Department considers have low rates of immigration to the U.S. So if you're from, I don't know, someplace like New Guinea or something, the State Department says, you know what, we don't have enough people from New Guinea in the United States. And so that's when they will open up a certain amount of visas to be allocated via a lottery system, and that's called the diversity lottery. Doesn't really happen with the countries that where most of our clients come from in Central America and Latin America because there's already such a large immigrant population from those countries in the U.S. You've got your defense from removal, which is a kind of a smaller portion of that. and that's, someone that's already here, they get picked up or detained in some way, and you're seeking withholding or cancellation of removal for someone like that. And those are really kind of just very technical type of arguments you've got to make there. Humanitarian-based immigration is really where we make our, hay, if you will, where we live in the unaccompanied minor world. And those are going to be your asylums and things like that, more or less, are going to be considered humanitarian forms of relief, right? And so I just wanted to give you a way to kind of visualize all these things that are floating out there as we're talking about it, and also to see how what we do on a given day or month is, SIJ and asylum for the most part. You have some Ts and U visas, but it's really a very small corner of the entire immigration world. So with that, I'm going to move into Government 101, I'm calling it, and this is really a basic overview of the U.S. system of laws. You've all heard all these concepts and proceedings before, but my goal is to put them in some sort of coherent order for how things play out with an immigration case, so you can understand all these terms and concerns that the lawyers have for their clients as we're going through the process, and where they come from maybe. So at the very big picture level, I want to point out the primary difference in our system as opposed to most of the rest of the world. This is important because we're often trying to explain complex concepts to children, and we forget that we're not only translating from English to Spanish, but really from a totally different legal system. So even if these kids did understand the legal system in their country, it wouldn't make much sense here either way. You can see here that common law focuses on court decisions, while civil law focuses on government legislation. And what that really means is that civil law countries try to legislate or have a statute on almost everything, right? They want to have a specific law or rule that will apply to every single thing that could happen. Whereas common law countries, we have laws, right? We have legislation, but we're not trying to legislate every possible scenario. We're trying to just get the big picture, and then the judges kind of say, you know what, I think this law applies to your facts or your case. Whereas in civil law, your lawyers are really arguing more about, which law to apply to it as opposed to how to interpret the given law that's there, if that makes sense. Civil law lawyers are going to be looking at kind of, I think this statute applies to what happened to my client. The other guy is going to say, I think this statute applies. Whereas in common law, you've got your judges saying, all right, here's the law, and you're arguing as to how the judge should understand that. And you can see here the general map of kind of where that plays out. And like I said, it's really the English common law system. So England and its former colonies, like ourselves, are what use that system for the most part. Moving on to the U.S., and really the foundation of everything, as everybody knows, is the Constitution. And within the Constitution, the first three articles create the legislative, executive, and judicial branches of government. And the legislative branch makes the laws, the executive branch enforces the laws, and the judicial branch interprets the laws. That's pretty basic stuff. So where does immigration fit into this scheme? We just said judicial branch is the courts. That should be pretty simple, right? Not exactly. Immigration courts actually fall under the executive branch of government, under the Department of Justice. And that's where it gets a little bit more complicated with how things play out. So here you can see on this super patriotic slide that we have the executive branch and the 15 cabinet-level departments that are under the president. And we're really concerned with 3, sometimes 4 of these departments, because the Department of State plays a large role in issuing visas as well, but they issue them abroad. So that's your consulates abroad that are going to do interviews on people and have certain types of immigrant visas processed to them. But we're mainly concerned about those children who have already arrived in the United States. And there you can see the Department of Justice, Department of Health and Human Services, and Department of Homeland Security are the big ones. So here's how everything fits in. And like I said, the 3 primary agencies we're concerned with are here, and we've got Department of Homeland Security up there on the top left, and that's DHS. I'm going to try to go through these and use all the acronyms too, because one of the hardest parts that I dealt with when learning immigration law was just the alphabet soup that one has to understand to be able to have a basic conversation when you're talking about these things. So DHS is Homeland Security, and within that, they oversee U.S. Citizenship and Immigration Services, which is USCIS. They also oversee Immigration and Customs Enforcement, which is ICE, and Customs and Border Protection, which is CBP, right? So USCIS is where we send most of our applications. ICE are the government attorneys, or TAs, among other things. They actually enforce the immigration laws. And CBP, as we know, are those agents who are down on the border and actually doing the apprehensions and enforcing the border. There on the top right, we have DOJ, Department of Justice. And this is where the Executive Office for Immigration Review sits. That's EOIR, and that's your immigration judges, your IJs. They also have the Board of Immigration Appeals, and I'm going to go into kind of how that appellate process plays out in a second. Down on the bottom left, you have Department of Health and Human Services, HHS, and they have ORR, Office of Refugee Resettlement. They oversee them, as well as the unaccompanied refugee minors. But ORR, as we know, is who runs the shelters that the kids are detained in while they're awaiting reunification. And you see the state courts fit into this pie for SIJ cases, but I'm removing them from this little graphic here to the side because it's kind of a separate process that you go through. But really, I just wanted to show you how all three of these agencies oversee different facets of immigration law, and they're all under the executive branch of government. So the federal court system, and again, this is jumping into the judicial branch. We have two distinct systems of government in the systems of courts in the U.S., and that's the federal system and the state system. And the federal system is broken down like you see in the picture here. Federal courts have what's called exclusive jurisdiction over things like admiralty, which is the law of the sea, if you will, antitrust, bankruptcy, copyright laws, things like that, things that play out at a much bigger level than an individual state could or should decide. It's got to be able to be applied across all of the United States. So within the federal court system, you've got your circuit courts of appeal, right? And you see here that Texas is in the Fifth Circuit. Fifth Circuit is generally considered one of the more conservative circuits in America as far as how they make their rulings. The Ninth Circuit is generally known to be a very liberal circuit and has much more favorable rulings for a lot of immigration cases. All of these circuits have total control over the states that are under them as far as the federal system goes. And again, I'm just telling you this so you hear us when we're talking about, is it a Fifth Circuit case, is it a Ninth Circuit case, why does that even matter sometimes, right? And so these are the kind of things that I want you to be able to understand when listening to maybe some of the decisions that are getting made about how to go through the case. So I mentioned appeals a second ago, and how does this all play out? These agency decisions, the agencies like USCIS and EOIR, are subject to an administrative appeals process, which itself filters up the chain and into the appellate jurisdiction of the federal appeals courts. These are admin courts or administrative courts under the executive branch of government, so they're not courts under the federal branch. And that's the AAO and the BIA. So USCIS, if you want to appeal a decision, you can't appeal everything. You can't appeal just because you don't like the ruling sometimes, but if you've got a reason, you can appeal, and you would go to what's known as the Administrative Appeals Office from USCIS decisions. And if it's an EOIR decision, if it's an immigration judge decision, you would appeal to the Board of Immigration Appeals, which is the BIA. And both of those, again, are under the executive branches of government. But what happens if you want to appeal one of those decisions? That's when you jump into the federal court system. And you can see at the top of each of these boxes here where I've got it set up, you see that it jumps to the judicial branch of government when you get into the U.S. federal court system after an appeal to AAO or BIA. And appeals from either of those bodies end up filtering all the way up to what could be the U.S. Supreme Court. if you had enough reason, if they take up the case. There's all sorts of factors involved. You can't just, go straight to the Supreme Court, and you can't just get a Supreme Court hearing because you don't like the lower court's ruling. They decide what courts or what cases they want to hear. So it's a complicated process, but again, I just wanted to kind of show you, maybe map it out a little bit so you can see all these different things playing out. Now going into the state court system, and the state court system is where most of our SIJS cases have to play out at some point, right? You've got to go through and get the underlying order about abandonment, abuse, or neglect. And state courts have jurisdiction over things that are not federal, right? Your typical day-to-day stuff, divorces and auto accidents and all those kinds of things are going to play out in state court. You can see here at number 3 on this, I'm not sure if my cursor is working. Right here where it says number 3, state trial courts of general and special jurisdiction. And then in this parenthetical here, some courts specialize by subject matter. Well, that's the level that most of our cases play out at, and that specialization by subject matter is your family court or juvenile court. They've got, judges who specialize in those areas. So in addition to all of the rules that go into just getting into court in the first place, each of these courts has local rules. So Harris County has its own rules for its courts. Tarrant County would have its own rules. And the attorneys have to be aware of those local rules as well. And on top of that, each judge has their own way of doing things, right? So it's important to know that these exist beyond just the general rules that are in the book. You've got to know the local rules and even the local judges. The attorneys have to worry about learning and complying with all the individual preferences of each judge. But you may know from having worked with another attorney on a case in front of a certain judge that they do things a certain way. It can't hurt to tell, the attorney that you're now working with or on a different case, hey, we were in front of this judge last month and they did not want the child to be brought into the courtroom when we did our prove-up, or little things like that, right? Remind them, and they can make the decision as to how to go about it or ask someone else. But these are little things that are individual to every courtroom, and it gets confusing. All right. With that, I want to go into civil procedure. Civil procedure is a first year of law school class that everyone takes. It's super complicated and very, arcane, I guess. But here I'm really just going to touch on 2 things that you hear about a lot, which is jurisdiction and due process. And I think these are important to at least have an idea of why they're important, where it comes from, so that when we're asking all these questions about where's the child now, where were they before, and can we do service, can we do waivers, all those questions that you hear all the time, these are actually the rules underlying them and where they come from. So first off, before you even reach jurisdiction, you've got something called standing. Standing is from the point of view of the person bringing the suit. You have to be an aggrieved party, or that is, you have to have something at stake in order to bring a suit. So with conservatorship or guardianship cases like what we see with SIJS, it means that a person has to have a claim to that child. This is the thing where a parent will always have standing, right? So if you're a parent, boom, you got standing because you have a claim to that child. If you're someone else, an aunt or uncle or anybody, you have to have physical possession of the child for a period of time before you can say, all right, I have enough grounds to sue for conservatorship or guardianship or something. And that's kind of a law in place so that a babysitter couldn't just file a custody suit after taking the kids to the zoo for the day, right? Yeah, they had physical possession of the child for 3 hours at the zoo, but that doesn't give them standing to bring a suit against the parent and try to get guardianship of the child or something like that. So they're really in place to protect from frivolous lawsuits and things like that. Now, jurisdiction, you see at the bottom there, and 2 types of jurisdiction, personal and subject matter. Personal jurisdiction is the power of a court over the person of the defendant, over the physical kind of body of the defendant, right? The idea here is, would it be fair for a court to make a ruling against this person? If you've lived your entire life in Texas, never left the state, for example, and someone's visiting from California and you get into a car accident with them on a Texas road, is it fair for them to go back to California and sue you in San Francisco, requiring you to appear in court there and hire a California attorney and spend money out there? Well, no. The California court would not have jurisdiction over you as a person sitting here in Texas, especially when the auto accident happened here in Texas. So the idea is that they have to be able to reach the object of the suit. Subject matter jurisdiction is the power of the court to deal with the general subject involved in the action. So on the same example as the car accident, if you wanted to sue the person from California, let's say they're still in Texas, you couldn't file your suit in divorce court, right? You can't file an auto accident claim in divorce court or something like that. It's really just, does this court even have the power to hear this type of case? A little bit more complicated than that, but for our purposes, that's what matters. So what does this really look like? All right, bear with me here. I'm going to get real Texas on y'all and real cheesy at the same time. Think of the court system as a tool for seeking justice, which is exactly what it is. The first consideration is standing. Are you even qualified to throw that lasso? Right? The second is personal jurisdiction. Does your lasso even reach the target that you're aiming at? If it's not long enough, or if you don't even know where the target is in the first place, you're out of luck. Finally, even if it reaches, are you at the right rodeo? Do you have subject matter jurisdiction? Because they'd probably kick you out of the arena if it's supposed to be a bull riding competition and you're trying to rope things with a lasso in the middle of the arena. For those of you who don't know me, this is a personal picture of myself throwing a lasso. For those of you who do know me, you know that's also a lie. All right. Concepts of due process. Let's move on from that terrible analogy and talk about due process, which comes from the Fifth Amendment. The Fifth Amendment has a lot of great things in it. This is, most famous for someone pleading the Fifth or claiming the Fifth when they're on the stand, not testifying against themselves. But for due process, it says that a person shall be, no person shall be, deprived of life, liberty, or property without due process of law. So what goes into due process? The big things are what's called notice and opportunity to be heard. We're not usually dealing with detention issues like this cartoon points out, but immigration is fraught with due process issues. There are basic due process issues that come into play on every SIJS claim, and you know it as service of process. And this is a big one that we're always talking about, trying to get service, trying to serve the parent in home country. How do we go about it? How do we get them to sign this or sign that? All of those factors. This all comes from the Fifth Amendment's requirement for due process of law. Right? It's not fair to sue someone if they don't even know they're being sued and if they don't get a chance to be heard, to answer. So service of process comes in a couple different ways. Here are the three major ones. Service, personal service is your traditional, you've been served type of thing, right? Think Pineapple Express, you've got your process servers who show up at the door, boom, here's the paperwork. That person then has to go back and file an affidavit saying they indeed gave the proper paperwork to the right person, and that person is aware that they've been sued in some capacity. You've got waivers, and waivers is a way for a person being sued to waive formal service of process. It's quicker and cheaper than going the formal route. There are also other advantages to this method in Texas Family Court, and I'm not going to get into it here because it's too technical, but you all know that one of the big things we ask when we're doing intakes or assessing a claim is, can we get waivers? Or do we know where the dad is? Something like that, right? And this is where those questions come from, because service of process is required. There's also publication, and this is known as alternate service. You usually have to try other methods first, and then you go to the court and say the other methods didn't work, and they can approve service by publication. This is basically a newspaper ad that says you're suing someone and it should be published where they might have a chance of seeing it. And it's got to be calculated to give actual notice. So that's why we can't start with service by publication. You've got to try other methods first, and then you've got to get permission to do it. But then, we're looking at, okay, do we put this in the newspaper in Tegucigalpa, so that this person might have a chance of seeing it, and the judge will be satisfied that at least they got some semblance of due process in this procedure. One final note is that you'll hear the Hague Convention mentioned in connection with service. It's an international treaty about foreign service of process, but it only applies to countries that have signed the treaty. So none of the Northern Triangle countries of Central America have signed it. Mexico has, and it would apply there, but generally it doesn't apply, in our Northern Triangle countries, and it's very technical and complicated when you do go through that process. So I just wanted to tell you that so that when you hear people saying, the Hague this or the Hague that, that's what they're referring to, and it has to do with the service of process, but it doesn't apply in every country if they haven't signed the treaty themselves. All right, we're moving along pretty quick here. Ethical rules. We've reached the fun part of the presentation, right? The ethical rules. I'm going to run through the really big ones just to flesh out some of the concepts like confidentiality that you hear about every day. From there, I'll turn to one of those things that you've heard mentioned over and over, but no one really defines it, and that's the unauthorized practice of law. So the very first thing, and I want to start by showing you how the lawyers are obligated to oversee the ethical conduct of staff so that you understand, A, that this applies to all staff in the law office, and B, why the lawyers are so, very technical about the way things have to be done sometimes. It's not that they're being mean or just overly cautious. These are just rules that apply throughout, and it's the lawyer's job, their bar license is on the line there, to make sure that it's done right in their office and under their supervision. So who does this cover? Here you can see there's ABA Model Rule 5.3. Texas has adopted an almost verbatim version of this. And the lawyer having direct supervisory authority over the non-lawyer shall make reasonable efforts to ensure the person's conduct is compatible with the professional obligations, right? The comment to 5.3 discusses secretaries, investigators, interns, paraprofessionals, so paralegals, caseworkers, and other assistants acting for the lawyer. Even interpreters and translators are covered. So the emphasis, the main professional obligation that comes up over and over is confidentiality. Confidentiality applies to the whole legal team, and it's really underscored throughout several different ethical rules. You can see here that 1.6a is the duty to maintain client confidences. 1.6c is that a lawyer is required to make reasonable efforts to prevent the inadvertent or unauthorized disclosure of information relating to the representation of a client. There's 8.4a also that prohibits a lawyer from violating the rules of professional conduct or doing so through the acts of another. So that's kind of how all that wraps together, right? They have an obligation to confidentiality. They have an obligation to make sure that the acts of someone else in their law office doesn't inadvertently disclose client information. So it's pretty clear that non-attorney staff have a duty under the guidance of an attorney to abide by the rules of ethics. But what are those and what should you look out for? So I'm going to touch on two big ones that I know you've heard about. Again, the confidentiality rule first. And this is, like I said, 1.6a. Lawyers shall not reveal information relating to representation of a client. As with almost everything in the law, there's exceptions to confidentiality, and you should at least be aware of two primary exceptions that concern us. The big one with confidentiality, and you'll also hear about attorney-client privilege, which is kind of a corollary to that, something related to it, is that the attorney has a duty to report ongoing crimes or imminent danger, things that are likely to result in death or substantial bodily harm, right? This doesn't really come up with our clients, but you could see situations, a client comes to you and you're their lawyer and, hey, I'm going to go rob a bank or something, right? Well, confidentiality is out the window because it's a crime that's about to take place. Someone could be harmed, da-da-da. You don't have to say, oh, I couldn't call the police because that would have violated, the confidentiality rules. So there's that big one. For our purposes, an even more likely scenario is what is known as mandatory reporting. And that's when it comes to child abuse. There are things that you are obligated to report immediately, and I'm going to touch on that here with the Texas mandatory reporting rules. I'm not going to read it to you or try to interpret it. I just want you to know it's something that's out there, and it has to do with allegations of child abuse, and the important thing is to know it exists and to discuss it with your supervisors as to how your office or your organization handles these situations. At the end of the presentation, I've included some information for how to report something under this statute should it ever be necessary. But again, this has to do with child abuse, and everybody can talk to their own organizations about how that plays out in a given situation. So what does confidential information look like in everyday practice? Going back to that idea, right? Practically speaking, what is the attorney-client privilege? And why do both confidentiality and attorney-client privilege play in to all this? The best way I've seen it described is it's one basic value in two different approaches. So a lot of times concepts of both of these are used interchangeably. For our purposes today, the distinction is not all that important. What matters is how this confidentiality plays out in reality. So I have a few scenarios and stories to try to illustrate the idea. So first, the idea of not discussing work outside the office. Sometimes you have to be careful in the office too, but discussing client matters, even with a spouse, is a no-no under the rules of confidentiality. Now, how does that work, right? Every one of us has heard an attorney tell a client story outside the office. You're at happy hour, and somebody's like, oh my God, you won't believe what happened the other day. So the idea is to never use any identifying information whatsoever, right? You would be betraying a client's confidences if someone knew who they were when that story is told. So I can tell you something like, I once had a client from Guatemala who got deported because they stole a cell phone. That doesn't really give much away. If you have to discuss anything, be very vague, right? Never use names. Don't even use exact ages if you can avoid it. The idea is don't give any information that would betray that particular client. The idea is really be discreet and try not to talk about things that you don't have to in these situations. But we're humans, and it does happen, and you have to use some stories for training purposes. What's the next thing? It is acceptable to discuss things with others in your own office because you otherwise couldn't do anything. It'd be impossible to, to represent someone in your office if you couldn't talk about it with each other. Let's say you're in the office discussing a case with a colleague. One of the things you have to think, okay, is this colleague on the case team? Are you discussing it in order to get advice or instruction on how to handle something, or is this just gossip? Are you in the hallway with other clients around? Are you in the lunchroom with staff from other departments? These are all kind of things that you have to ask yourself. Be careful where and how you're discussing the details of a client's case. Just think about it and be aware of your surroundings. If you're discussing things with your case team, shut the door or go to a more private area. The idea, again, is to just be discreet. Now, there are other actual kind of physical concerns and measures that go into confidentiality. So physical file setup is one of them. Where is your intake form located in the file? This has very sensitive information, right? This is kind of what really happened to this child and all the information about their parents and everything else. You probably don't want it as the top document when you open up a file, just in case other people could see it if it accidentally got dropped. Be careful what you write in the progress notes or your case file notes. This should not be used as an interview section. It's much more of a case tracking log. So you want to be sure that you're not doing it to where it could be easily viewed by other people when you're transferring files, that kind of thing. You see here on the slide, think about the way you handle the files. The organization of your desk is a client confidentiality issue. If you've got 20 files sitting on your desk, 3 of them are open, and all of a sudden, somebody walks in and is like, hey, can you do this intake for me real quick? I have to do something else. And, a kid's sitting on your desk all of a sudden, and there's a couple of files of other kids on the desk. You want to take measures to lock up physical files as well. Again, that's just in case, it sounds crazy, right? In case the office is broken into or something. Think about the way the files are organized, I already said, and which documents are located where in the file. Computers should be locked to a desk. So we mentioned there are network and IT security considerations, but there's also the physical safety of the computer. The IT security considerations are things about, you know, having access to your electronic files. So this means probably, you know, more logins and passwords to remember than most of us would like, but they're in place for a variety of reasons, and one of those, among others, is this confidentiality idea. In all these scenarios, the way the clients see you treat other people's information, whether it's the physical file or a conversation they overhear as you're walking them back to the lobby, right, is an indication to them of how you'll protect their info and their confidence in your ability and your team's ability to represent them. You know, we all have clients walking in and out of the office all day. A kid overhears, you know, two attorneys talking about another kid's case or something like that. Most times we think nothing of it. Sometimes we think, oh, I was speaking in English. They're not even going to understand me anyways. You know, you just can't think like that, and you have to take proactive steps to try to maintain the confidence of your clients by maintaining confidentiality of all other clients. So I mentioned earlier unauthorized practice of law. We hear about this all the time with notarios in the States, but it's also something that you hear about. I'm sure all of you got trained on the idea of not giving legal advice yourselves. Where does that come from? You can see here the unauthorized practice of law. The definition is very broad, but it's really kind of the study of facts of a case and the applicable laws, coupled with the giving of advice and auxiliary activities, so other activities. And that's kind of like the services to be performed require appropriate training in the law, right? And the exercise of professional judgment in applying the law. So other definitions of providing legal advice might be holding oneself out as capable of providing legal advice. These are things that we spot right away when we see a notario doing it, right? And we're like, oh my God, they gave terrible legal advice. They told this person they were qualified to do it. And it wasn't just filling out a form. It was, oh, you need to fill out this particular form, and this is how you're going to do it. And they hold themselves out as if they have studied the facts of the case and are applying the law to it. But again, that's the same reason why we have to be careful in everyday practice in the law office, and non-lawyers should not hold themselves out. So I hate reading words on the screen to you, but I'm going to do it because there's really no better way to put this than how it is here in the top left box. And when does a non-lawyer cross that line, right? If the non-lawyer provides legal advice that reflects his own judgment, such as recommending a particular remedy for the client to pursue without being adequately supervised by a lawyer. In the immigration context, a non-lawyer might provide such advice during an intake screening of a prospective client or when working directly with the client without any level of supervision. Another example of unauthorized practice is the person gives the appearance, intentionally or unintentionally, that he or she is a practicing lawyer by not identifying themselves as a non-lawyer. So nonprofit legal service providers must be particularly careful about this potential problem. This probably isn't news to you, but this is why there's such an emphasis on avoiding the appearance of giving legal advice. The clients will see you as an authority and not make that distinction themselves. So just be sure to remind them of your role throughout the process, whatever that role is, because the clients will get confused and start talking one way or another, and it's easy for you, because you often do have a lot of training and knowledge, to say something that might cross that line, right? I'm not trying to scare you, I just want to make you aware of the idea that you need to be aware of that line. Now finally, we have kind of tips on working in a law office, and a few takeaways from all this stuff I was discussing earlier. This is certainly not a comprehensive list in any way. Really, I'm focusing on these few small things here because they don't take any special training or years of experience. Anyone can do these things, whether you're just starting out or whether you've been doing it for years, and it'll really help working in any office probably, but particularly a law office and working with lawyers. So first thing there is attention to detail. The lawyers can't do their work and the clients don't get decent representation without each of you. Attention to detail matters because if something gets put into the wrong sheet or not put into the file, or the A number gets entered wrong, it's going to cause so many problems down the road. So little things like always double check your numerical entries, right? You're writing down a phone number. Check that phone number against 2 other places in the file if you can, because it's really easy to transpose or mix up the numbers. Same with A numbers especially. Like look at the VRF, look at the verification of release form, make sure the A number you're writing down is the same as that, and make sure that A number maybe is the same as the one on the NTA. If they're different, or maybe we're going to write it down wrong, but it's always better to check it so that when you're writing something in there or typing something in, you make sure that it's the right number. And if it's not, that's something you bring up right away, and it's better caught early rather than late in the system if sometimes the government messes up and has the wrong A number. Documenting client communications. This goes to the duty to communicate with clients and to issues of withdrawing from a client's case if it's ever necessary. The progress notes or case sheet, whatever you call it, should be filled in with the time, date, and type of communication, because this is really important for practical and ethical reasons down the line. If we ever have to withdraw from a case, we have to be able to show the judge, this client was maybe not participating in their own representation. They weren't returning phone calls, they weren't showing up for meetings, and the best way to do that is to show, look, the caseworker called them on this day at this time, no response. They called them again the next day, different time, no response. All those kind of things are actually going to be put into the motion to withdraw most likely if it's necessary, so that the judge can see that you did your due diligence as a lawyer and that your legal team did things correctly all along, right? And then finally, I want to switch gears to translations and interpretations, because these are things that are often at the heart of proving any client's case with evidence, and they're also necessary in every case with at least like a birth certificate or something that you have to translate. So a really broad kind of quick overview of translations is, what's the first thing you should ask yourself when someone says, hey, translate this document? You want to say, why am I doing this? Not say that out loud, like as in, why would you ever give me that? But the idea is to get the big picture down first, right? Is this a birth certificate that's going to be used to just prove the age of the client like every other birth certificate? Or is this one different because this client is a twin and Guatemala got the records mixed up years ago and we're trying to prove that it's actually the other person? You want to know that picture level, because you want to know kind of what the judge and what the people that are looking at the translation are going to be looking at specifically. So what is this document and what is it being used for? Before you start, you always want to ask, and this really goes to everything, but when is it needed? So there's a big difference in a 1-hour turnaround and a 1-week turnaround, right? You always need to do a good job and need to translate accurately, but the reality is we all understand that some things, is this a quick and dirty, just give me the birth certificate as quick as you can, or, hey, this is going to be scrutinized, so I need you to really look at it and take a whole week and make sure it's perfect. There's all those factors that go into it. Ask that question. Get in the habit of asking that question of the attorney or the supervising paralegal, whoever assigns you a project, because it really affects how you do the project, right? Document setup. Review the whole document before you start translating. Sometimes people give you a newspaper article, and you want to look at that and see if there's any special terminology used that, maybe at the very end there's a word that you've been translating, something else as the whole time. You want to see if there's any special words, special terminology that you want to look up, or even ask the attorney or others, hey, how would you translate this? Because later in this document, it becomes the crucial part of this sentence or something. So again, is it a chart, a letter, a certificate? All that's going to go into how you start the setup in Word and how you actually translate the whole thing. Is it something similar to what we've done before, right? Don't need to reinvent the wheel. If there's a template out there, if you've done 30 other Honduran birth certificates this month, then you probably have a pretty good template down, and I'm sure most offices do already, for how to do one of those with, the seal in the right place and the lines in the right place and all that stuff. You all know you can change the language under the Review tab on Word, change it to Spanish. so that it'll catch spelling errors. You know, I've seen translations that get translated accurately, but there's spelling errors in there. You know, if you're going into Spanish, or even if you're going into English, really, rely on Word if you can. And always read something over before you turn it in. And there's also the final component here about a literal versus a comprehensible translation. Comprehensible is what we want, or what we need. It's got to be understood, right? We've all put something into Google Translate, and it spits back out maybe a literal translation of the words on the page, but not anything that really makes sense for a judge to read and say, oh, this is what they're trying to say here. So just be real careful about how the document's set up and maybe the way in which you go about translating it, because the end product has to be something that's usable in a court of law. Okay, so back to my original question. What are the attorneys talking about? They're often in a hurry. You can see from this presentation that there are so many factors that go into every decision made on behalf of the client, from the proper legal analysis to complying with ethical rules to contractual obligations, and each organization has their own. Know that the attorneys and you represent the client together. That's why the ethical rules apply to the entire legal team. The clients can't get representation or even basic legal advice without your role in the process, because no one can do this all on their own and represent more than a handful of people. So my advice really is take initiative, try to learn every day, and ask questions. You know, hey, what's that even mean? Or, you know, I don't want to tell you to ask, why am I doing this? But again, you want to understand what certain things are going to be used for, or why you're setting up things in a certain way, because you're going to be able to do your job better. The work of any legal office, and especially a nonprofit legal office, like where most of you work, is impossible without dedicated caseworkers, paralegals, clerks, assistants. The lawyers are generally smart people, for the most part, but what good representation comes down to is understanding the law, having experience, and using common sense. And these are things that each of you has and can build on. So I'll end with this cheesy image and take questions in the chat box if anyone has any. And you also can see my contact info here at CILA. You know, we do a lot of technical assistance, and obviously I would tell you go to your supervising attorneys first with your questions. But, you know, if they ever say, hey, check with CILA on this, you know, feel free, please. And here's my personal, my email and our CILA phone numbers. So if there's any questions, I'd be happy to touch on any of those things we talked about, or just something maybe I completely forgot to mention. This is a great chance. Please put it in the chat box, and we'll try to get to them. While we're waiting for some of those to roll in, I have this one final slide about the mandatory reporting contact info. Again, this is something you should take up with your supervising attorneys, but if you ever do feel that there's something that needs reporting right away, and for some reason you can't you know, get anyone else to weigh in on this decision, it is a personal obligation that each person has, and here's the information for how to go about doing those things. Yeah, if you don't have any questions, thank you for joining us today. I hope that wasn't too boring. But again, we're here to be a resource, so please use us. And I'll be on the line for another few minutes too if you're still formulating your questions. If not, y'all have a great afternoon and rest of the week. Yeah, so one of the questions is about literal versus comprehensible. Comprehensible, I meant, is an understandable translation and what situations where that would matter. Sometimes you actually want to show maybe that the underlying document was done wrong. Let's say you've got a bad birth certificate or something from home country. So you want to translate it literally to show the judge that, you know, not only was this birth certificate, the date's wrong, but look, they didn't even spell the name of their own agency right in the header of the document. This shows the judge, on our end what a Mickey Mouse kind of organization it is. So you want to do a literal translation of that, right? You don't want to fix their mistake because you want that mistake in the translation to show the judge kind of what you're trying to get across. That's different from a comprehensible or understandable type of translation where you're translating maybe a threat letter from a gang, right? Their spelling is often horrible in Spanish, and you're not going to translate literally everything. Certain curse words just don't have good translations, right? You want to basically get across the content and the meaning of the underlying letter to the person reading it in English, but you're not going to be able to translate it word for word type of thing. Does that make sense? Someone asked about The Hague and what that is. Well, The Hague is actually a city in Belgium, Amsterdam, I guess the Netherlands, excuse me. But what it is that's where many international treaties are formulated and started, and so they're all referred to as The Hague this, The Hague that. What we're really talking about there is the Hague Convention on Service of Process in foreign countries. And so it was a way of people not having to deal with their own domestic laws each time. You know, if we have a case that's also going on in Ecuador, you want to be able to use The Hague if you can. But again, it doesn't really apply in the Northern Triangle countries. But I wanted to tell you that because you often will hear people talk about, hey, The Hague, does The Hague apply here? And that's usually what they're getting at in the service of process context is that Hague Convention. And you need to look at whether both countries involved are signatories or have signed that treaty. How should you deal with punctuation in translation is a great question. For example, what about documents in Spanish that don't have any punctuation? Yeah, that's another one of those situations where I would advise people to err on the side of making it understandable, right? I mean, yeah, because you'll have documents in Spanish that are just a whole page of one run-on sentence. You can insert punctuation if it's inserted in order to make the document understandable, right? You never want to change the meaning of the underlying document you're translating, but it has to be able to be read by an English speaker or vice versa, I guess. And so, yeah, you can insert punctuation in order to make it understandable for the reader in the other language. That's not, outside the bounds. Yeah, so that's adding punctuation to a translation. Again, so long as it doesn't change the meaning of a sentence or a phrase, you can't stick a period in where it doesn't belong to make things look like it was two different thoughts. But if it helps the reader, then that's just fine. All right, well, I think that's it. Again, thanks everybody for joining. Feel free to reach out to us all, and yeah, everybody's doing great work. It's really important, everybody's role as part of the big legal team, and I hope this helped to at least understand some of that jargon and all those terms that the attorneys throw around all the time, and we forget that we learned our fancy $5 words in law school, and, they're not really that fancy. So y'all have a great day. Thank you.